Hello, everybody, and welcome to the research process videos. These videos are part of the legal writing course online. So what we'll be talking about in this video, basically, we'll be walking through an introduction of the research process. So our learning objectives. First, we want to describe the steps of the research process. Then we'll talk about the techniques that we will use throughout these processes. Then we'll talk about and need to learn and understand the iterative nature of this process. So we won't just conduct a search, be happy with that search, and then our research is finished. That rarely happens, if at all. We conduct searches, we assess the results, we learn from those results, then we take that learning and feed it back into more searches. So that process is repeated. It's iterative. Then we'll talk about some techniques we can use when we find too much stuff or we don't find enough stuff. So researchers rarely find the right amount of information they need that's exactly on point. We're usually faced with too much information, not enough information. So the essential steps of the research process. And again, these steps are in what some would consider to be a logical order, but they may not be in your most logical order. So use what you think is necessary to get to the destination. But we'll explore in these videos what I think is a good way to approach the problem and what the authors of the book have proposed as a good way to tackle the issue. So first, we really want to just familiarize ourselves with the legal problem. We might have a question from a professor, from a supervising attorney, from the people in the business department, from your supervisor, wherever that question comes from. It could be a client. We want to just get familiar with the landscape, with the lay of the land, right? A lot of this can be accomplished nowadays with a quick Google search. I wouldn't finish with Google, but just to get our minds oriented to what the problem is. We always need to be cautious about Google, but I think it's an okay starting point to get our mind oriented in the right group. So, for example, we could look at some articles that maybe other attorneys have written on their websites. There might be client alerts that they've written online. Government entities might have a web page that describes the issue where you can look for further information. But with anything on the internet, you always want to be cautious, right, about the source of law. For example, if it's just a blog post from a random person who may not be an attorney or a law librarian or someone who's an expert in that particular field. So just be cautious, but you can use Google or your favorite internet search service to just get the basic landscape. Then what's involved in familiarizing yourself with the legal problem is asking yourself who or what's involved in the problem. Is it between people? Or is it a company? Or is it a government entity? And then what's the relationship between those people? Are you looking for information about a dissolution of marriage between two people? Is it a criminal issue between the government and a defendant? Are you in the M&A field? Export control. So who's involved and what's their relationship? So once you do this, you'll likely get some facts about the legal problem that you'll use to learn to answer questions about the legal problem. And during this process, you'll come up with new questions to ask. So what happens is you think you have the right question, you start asking those questions, and then you realize, well, maybe that wasn't the right question to ask. Maybe that was the right question to get started, but that question turns out to be of minimal legal significance. And here are the legally significant questions that we need to be asking. And when you're looking at this initial kind of familiarization with the process, be sure that you're noting the source of the information you're getting. And we'll talk about this in later videos, but is the source a primary source or a secondary source? We can use primary sources or secondary sources. You can use any source you want, but you always have to be mindful of the weight to give particular sources. Primary sources are always of the highest weight that we give. Secondary sources, depending on the source, are of a lower weight. But they all can inform us about the legal issue. And that's kind of where we're at this, the research process stage. We'll talk more about using primary and secondary resources and what weight to give them further down the line. But now we're just kind of getting an understanding of the landscape. So now when we've kind of understand the landscape, we can start and we've understand the questions or the new questions or the more legally significant questions. Then we start to define the scope of the research a little bit more. Now we kind of narrow that box of research slowly and slowly. So how do we do this? When you do kind of initial research, you'll find all kinds of things online, or if you're using an electronic service like Westlaw or LexisNexis or Hein Online, you'll initially probably find a lot of stuff. So to narrow the scope of the problem, what we'll want to do is do some kind of really easy narrowing techniques. So for example, what jurisdiction's law applies to the problem? And in international law, this is one of the first questions you always ask. What law applies? Sometimes that might not be totally obvious. Sometimes there are multiple jurisdictions that may need to be discussed. But if we can narrow it down to a jurisdiction would be ideal, or a few jurisdictions law, that would be great. Then we talk about this idea of venue. Like if we're talking about a court process, a legal action in the court, where is that court? What court would we file it in? Then we'll talk about, or one other way to kind of narrow the contours of our research is to make decisions on what the area of law is. Based on our question, based on the facts, do we have an area of law that we're dealing with? And in this situation, you would start with something like, is it a criminal law case? Is it is it a civil issue? And then if it's criminal, what kind of criminal law are we talking about? Was there a violent crime? Is it a misappropriation of trade secret? Is it some sort of white-collar crime issue? If it's on the civil side, are we talking about the sale of goods? Is it a contract? Is it a marriage issue? Is it a will issue? That sort of thing. So kind of taking these broad areas of law and slowly reducing the scope of that law. So then at this point, you might want to say, okay, we've got the choice of law, we've got the jurisdiction, we have the area of law. Now, can we write an issue statement? Can we rephrase that initial question into a more concrete issue statement? And you don't have to phrase it in legalese. Just kind of use your own language to rephrase the issue. We'll get to the legalese later. Just like if you were talking to someone in a coffee shop, how would you describe to that person what the issue is for this statement? Then, after you've done that, you might want to start to list out, or in your mind, start listing out the source of authority that you'll need to address this issue. And listing out that authority from the most important to maybe not so important. Again, this is just kind of an initial way to tackle the problem. Now, moving on to techniques for defining the scope of the research. What I like to use almost as an initial search are secondary sources. What's that? So, law review articles, treatises. These are sources that people who are much smarter on the issue have written to help people like you and me get smart about the issue. Right? So there are these things called practice series on a specific issue of law, law review articles. And we'll talk about more about secondary sources in the following videos. But these secondary sources are a good way to start really digging deep into the issues relating to the issue. So now, search queries. We know we've asked the questions, we've redefined the questions, we have an issue statement, we've consulted some secondary resources, we've gone online. But then, how did we find those secondary resources? When you're in Google, what keywords did you use? Did those keywords work for you? Were they bad keywords? Are there better keywords? So there are certain techniques that we can use to run searches that will give us the most optimal search results. And we'll talk about this more in the electronic research chapter. But just to talk about this broadly, if you have a copyright issue, you could search for copyright. Or if it's an intellectual property issue, you could search for intellectual property. But then you have to ask yourself, are those search terms going to be useful for you, right? So copyright is that will get you millions of search results. Same thing with intellectual property. So we need to start narrowing the results. And this is kind of where the iterative process comes in. So we could search broadly for copyright. That probably won't be helpful. But taking another term related to the issue and searching for that. And then discovering new terms related to that. And in this process, you're getting the vocabulary that's necessary to create these search queries. So we're kind of creating the lexicon of relating to a specific issue, where we're teaching ourselves the vocabulary of a certain area. Right? So if you were a scientist, you have a specific vocabulary. If you're a scientist who studies a specific sub-area, you have specific vocabulary. It's the same thing for the law. Usually, attorneys at least start as generalists and then focus their way down into a specialty. When we conduct research, we're doing the same thing. We are starting as a generalist, and then we are teaching ourselves and becoming a specialist with this specialist vocabulary. So once we've taught ourselves this vocabulary and utilized search terms, which we'll talk about more later down in future videos, now we need to start gathering material. So we're going to use these search terms in meaningful ways to gather primary sources. And we want to make note, write those primary sources down, primary source of law, case, and make sure we are saving that information. And at the same time, remembering that we are still in this broad sense. We haven't narrowed it down too much, but definitely we've narrowed it down from our initial kind of question. Then we want to focus on, okay, what is going to be binding for this issue? And we want to make sure that we're gathering that information and recording that information. So, okay, drilling down on these primary sources. Again, I like to use secondary sources to inform myself of what the primary sources are. So law review articles, practice series, treatises, that sort of thing. Then we'll want to research constitutional provisions, statutes, regulations. So when we find something, for example, a constitutional provision, we also want to make sure we understand that constitutional provision. So for example, you might want to look for annotations relevant to that constitutional provision. Annotations are there to help those of us who aren't experts in a particular law become more informed about that law. We want to do that with constitutional provisions, statutes, regulations, and judicial opinions. We'll also search for judicial opinions relating to that vocabulary that we've learned through our research process. We'll want to look at the head notes of the cases, of the opinions. And we'll look at Westlaw as one example of some head notes. You'll want to use what's called a citator, right, to trace the issue forward in time. Why do we do this? If we find a case, we want to make sure that that's still good law. So we use usually an electronic service to help us take that case and look forward to cases or things that have cited that case to make sure that there isn't new law or the contours of that case haven't changed. So not only do we want to look forward if we're looking at a case, we would also want to look backwards too. And how do we look backwards? Basically, we're looking at the cases that that particular case cites to. So if a case cites to a case, that's kind of like looking back to a previous case. We always want to consult those cases as well, because they may inform our research and inform the contours of the legal issue that we're exploring. So after we have these primary sources, these are constitutional provisions, statutes, regulations, judicial opinions, we want to make sure that we are looking at the good law, what we were talking about before. Is it the most recent law? For cases, there are cases constantly being published. For statutes, we want to make sure that we have the most recent statute or the most recent regulation or the most recent opinion of a regulatory body about that regulation. So these so-called citators are the best sort of way that we would make sure we're still looking at good law. And we'll look at that more in the electronic research video. Okay. So now talking more about this recursive process or iterative process. So with any legal research, the process isn't always linear. There's you go down a path, you might take some turns, You might take small turns. You might take bigger turns. You might take U-turns. And not only will you be going forward, but sometimes you'll go forward and need to reflect back. Okay, am I going down the right path? Do I need to reassess the path I've gone down? So now we're taking what we've learned at a certain point and maybe taking a few steps back and going forward in a better, more informed way. So for example, after you've looked at some secondary sources, you may learn that you haven't really identified the right law or the right issue or what jurisdiction you should be in. That might inform your issue statement. As more information is gathered, then you likely will explore a more nuanced search query. And that more nuanced search query might lead you down a different path of primary sources. So you might start writing. You might feel like you're ready for an analysis. And then realize that what you're saying isn't really backed up by any particular source. So then you might have to go back and revisit what you've looked at to find maybe something you've overlooked. And facts. The facts that might be relevant at the beginning stages might not be legally relevant facts going down the line. And there's always this kind of anchoring bias where you've gotten an assignment, you've gotten the issue, and maybe that supervising partner, you admire their intelligence, or the professor that is an expert, but maybe that question isn't right. So don't be afraid to explore these alternate questions and point that out to your supervising attorney or whoever your supervisor is. They will be appreciative of that. And then always realize, too, that the process, that part of the iterative process is you may not approach or linearly move forward with step-by-step use of authorities. What do I mean? You might start with secondary sources and move forward to primary sources. And then feel like you're satisfied with the primary sources that you've found. But your primary sources might inform more of your research with secondary sources. So you might go back to secondary sources. You might go over to some treatises then. You might update the vocabulary that you've been using. So just kind of emphasizing that it's an iterative process. It's not static. It's not linear. And it's personalized too. You have your own background. You have your own set of knowledge or vocabulary about the issue. You might be starting in a different place than someone else might be starting. Okay, to wrap it up, some concerns that you might have in the research process. When do you know when to stop? It seems like you could go forever and ever, and especially in big law, when the stakes are extremely, extremely high, that you would want to research into infinity, basically, to get the right answer. But we can't do that. There's a deadline. We need to get that research out to a client. We need to make that decision. So how do we know when to stop? Generally, if you found the authorities that answer the initial statement, and you've looked at other relevant authorities, you've looked at many different secondary sources, treatises, primary sources, if you're getting that same answer, then you can, with a certain amount of certainty, feel like you can stop. But I would always say that there is value to a healthy amount of skepticism about your own research. Asking yourself, is this enough? Is there something out there that I'm missing? Especially if you come to the answer relatively quickly. That's when I used to always ask myself, step back and say, is this really this easy? It could be, but are there other things I need to be exploring? Now, not finding enough relevant authority. This can be an issue. So I would suggest going back to the initial information that you got. What was the initial question? And is there something you're overlooking? You might, at this point, maybe go back to your supervisor or supervising attorney and say, hey, do I have this right? Do I understand this question right? You may be overlooking something at the initial stage. You could also go back to the secondary sources that you looked at. Reread those. And think about the vocabulary that you've learned that inform your search terms. Do I need to broaden that vocabulary that you're using? If you think you've searched or have found primary sources in the good secondary sources, maybe go out to the periphery a little bit more and look at some persuasive authorities, authorities that you might think are not relevant. Those might inform you. So kind of taking that box and pushing the contours back out again. You could always ask a reference librarian, a law librarian. Fantastic people. And just be kind of prepared. This is what I've done. I'm getting a dead end. Can you make some suggestions? Not only librarians, colleagues that you might have, an old professor. So then finding too many relevant authorities. You can almost do the exact same thing. Say, look at the initial question. Did I misunderstand it? Is this too broad? Go back to secondary sources. Am I thinking about this too broadly? Same thing with search terms. Do I need to narrow those search terms? Again, you can always just go back to a reference librarian or your friend or colleague or former professor. So, in conclusion, remember that this is, people say it's an art, right? Not a science. And it's one of those art forms that you're informing yourself as time goes on. So, and it's through that informing of yourself that you need to go back and revisit your initial thoughts about the research. Because again, you might have some anchor bias, and just realizing that it's an iterative process, that you need to remain open. So that's all I'd like to talk about in this initial research process video. Thanks everybody, and we'll see you in the next video.